Witness confidence. Is a highly confident witness more likely to be believed by jurors than an uncertain witness? The experimental evidence certainly suggests that mock jurors are more likely to be persuaded by testimony from a confident witness and so return a guilty verdict. Conversely, jurors place less credibility on the testimony of the less confident witness, given that, as noted previously, witness confidence is not always a reliable index of accuracy. A belief in a positive relationship between confidence and accuracy is not necessarily a good thing. Interpersonal perception. Are jurors influenced by emotion, sympathy, and prejudice? For example, the perceived physical attractiveness of the defendant can lead to a favorable outcome, but an attractive defendant with no justification for their offense may be seen in a more severe light. Similarly, defendants of high socio-economic status may be seen as less blameworthy for their offense, while a gender bias suggests that females are less likely to be found guilty for reasons of insanity. Finally, children are seen to be less reliable witnesses in court than adults, which may not be the case. However, the evidence gathered from real jurors suggests that jurors' decisions are not greatly influenced by the perceived characteristics of victims and defendants. Jurors heading. Jurors selection. There are formal selection criteria for jury service such as age and eligibility to vote, and as if they satisfy these criteria, any individual may be called for jury service. Nonetheless, objections may be raised in specific cases. For example, an individual with a known prejudice against another group of people would not make impartial jurors in certain trials. It is prudent, therefore, to allow the screening out of unsuitable jury candidates on a trial-by-trial basis. In practice, screening procedures are concerned with prospective jurors' exposure to pre-trial publicity of the case in hand, their attitude towards the offence being tried, and whether they know anyone involved in the case. The selection of jurors is often an emotive issue, taking a great deal of court's time, and raising the ethical issue of whether this process should use scientific jury selection informed by psychological assessment. The proponents of scientific selection argue for an empirically based method of selecting jurors. Opponents hold that selection is unsafe and contrary to the principles on which the jury system stands. Juror competence. Jurors may be required to assimilate a range of evidence presented during trial and to understand the judge's presentation of the issues before they reach a verdict. Several studies have looked at juror comprehension of the evidence and understanding of judges' instructions in complex cases. The typical finding, perhaps not unexpectedly, is that some jurors can struggle to make sense of the proceedings and to evaluate the finer points in the case made by prosecution and the defense. Heading: Reaching a verdict. The real process of jury deliberation during a trial is impossible to research at first hand. The nearest that can be achieved is either to observe mock jury deliberations or, where it is allowed, to interview jurors after a trial. The extant research attitudes alludes to a group dynamics of structure, process and decision making by 12 people thrown together in a highly charged situation. The jurors must appoint a leader, poll views, debate the evidence, recount the judge's instructions and seek to apply the law to the evidence. Thus, jurors may well be in a state of continual negotiation with disagreements and conflict, which may lead some jurors to become anxious or angry. It may be that the issues become personal, even insulting. Some individuals may refuse to revise their opinion. Some jurors may even refuse to participate, sitting apart from the others, and subgroups may form within the larger group. The jurors' deliberations may be influenced, particularly in the long trials, by resentment such as seeing the defendant as responsible for interfering in their everyday lives. Further, while sentencing is not the concern of the jury, jurors may reach a verdict on the basis of what will happen if they return a guilty verdict. The process of jury deliberation is clearly important, and indeed the research suggests that almost one-third of jurors do change their views during discussion. However, the best predictor of jury's eventual verdict is the balance of opinion among jurors at the onset of their deliberations. It is impossible to know how often juries make wrong decisions. It is likely that innocent men and women have been sentenced because of a wrong jury decision. It is equally likely that guilty people have been set free. A comparison of the judge's views with the jury verdict offers an insight into the frequency with which jurors reach a verdict that is at least at odds with an expert opinion. American research has compared the convictions and acquittals of judges and juries, finding that in more than 3,500 trials, the judge and jury agreed in 78% of cases. When they disagreed, the jury acquitted in 19% of cases, where the judge would have convicted, leaving only 3% of cases in which the judge would have acquitted but the jury found guilty. English research has reported similar findings. Most of the time, judges and juries agreed, and in instance of disagreement, the jury was more lenient. There are several possible reasons for juror leniency. A defendant with no history of offending may be given a greater benefit of doubt. The jury may feel sympathy towards the defendant, or in some celebrated cases, the jury disagreed with the law. Of course, to follow the point made above, the jury may reach an incorrect decision because of a failure to comprehend the high standard of proof needed to reach a decision, or because of a lack of understanding of the evidence or a judge's instructions and its appreciation. Next heading, Strength of the Research, page 195, Behavioral Forensic Psychology. A body of research evidence has accumulated that is relevant to the psychology of evidence. However, a great deal of this research, perhaps particularly in the area of eyewitness memory, has been carried out in laboratory settings. Laboratory-based research has obvious advantages for the researcher. It allows the investigator to control what the observer sees. It allows the investigator to select observers, say by age or sex, and it allows control over how the process of recall and recognition is structured. Indeed, the issue of control is central to laboratory research. By controlling as many variables as possible, the investigator can be discrete with a high degree of confidence the effect of the particular variables of direct interest. For example, in laboratory settings, observers generally recall violent incidents less accurately than non-violent incidents. The key issue is therefore the generalizability of the findings, that is, to what degree does the laboratory-based research inform understanding of real-life cases. Critics of experimental studies have pointed to the limitations of laboratory studies, such as the use of staged crimes and filmed sequences, and observer awareness of the focus of the research as a means by which to understand the complexities of the task facing a real eyewitness. The limitations of laboratory research are such as to minimize the realism of research and hence their applicability to real life. This point may be followed by questioning the professional wisdom of psychologists acting as expert witnesses and presenting such findings in real cases. Indeed, a field study by John Yule and his colleagues considered a real-life case in which 13 out of 21 witnesses to a shooting incident were re-interviewed 4 to 5 months after the event. The performance of the witnesses varied in a number of ways from what would have been predicted from the laboratory research, particularly with respect to effects of violence and memory. Should the findings from laboratory-based studies be disregarded in favor of field studies? The problem is that field studies are open to criticism on the ground that are the very strength of laboratory research, that is, the sacrifice of control in the field setting. In the field study noted above, it is not known to what extent witnesses conferred with each other, how accurate the missing witness would be, and whether media coverage had any influence on what witnesses had to say when re-interviewed. Is there a solution to this apparent impasse? While it is unlikely that two positions can be fully reconciled, there are two steps that can be made. First, with regard to the extent research, it is evident that not all the factors studied have an equal strength with respect to their relationship with the accuracy of eyewitness memory. Three categories of research findings have been defined: reliable and strong factors that have consistent effect on eyewitness memory, reliable and moderate factors that show effect on some studies but not in others. Third, weak or non-influential factors that have little or no effect on witness accuracy. In real-life cases, the psychologist acting as an expert witness may wish to refine their expert testimony to emphasize strong rather than weak factors. Second, looking to research design, the optimum approach is to gather data using a variety of research methodologies, including laboratory studies, case studies, field studies, and archival studies. Studies that are able to use a range of methodologies and produce consistent findings will considerably reduce the quite proper reservations about applicability of research. Conclusion. The historical emphasis in much of the psychological research has been to eliminate the fallibility of human performance, so alerting the criminal justice system to the potential for error. However, Psychologists have also turned to the more constructive task of considering ways to aid the gathering of evidence. In particular, psychologists are studying ways of enhancing the quality of witness testimony through the use of more sophisticated interviewing procedures. The cognitive interview, which uses memory retrieval mnemonics to enhance the recall, is one aspect of the developing field of investigative interviewing. For future, forensic psychologists seem set to give increasing attention to the development and refinement of constructive approaches in applying psychology to the complex process of gathering evidence. This article is over.